Good evening. You're watching ANN7 Prime. My name is Cindy Mabi. Good to have you. The judgment in the Gupta-owned enterprises versus the Bank of Baroda case will be handed down on the 21st of September. The group, whose accounts are facing closure by the bank, is seeking urgent relief to compel the Bank of Baroda to extend their termination deadline. The Bank of Baroda is the only bank conducting business with the companies after almost simultaneous severing of ties by four major banks. Oak Bay Council say there is no proof of reputational damage to the Bank of Baroda after business ties with the Gupta family-owned enterprises.
The entire issue of reputational damage is actually fallacious, and it's fallacious for this reason. Because if the court orders the bank to keep these accounts open, that's a perfectly acceptable reason for them to put up in the marketplace. So, my lord, to put it simply, if they say to your lordship, we are suffering such great reputational harm that this will completely undermine our business in the next 2 months, what I'm submitting is your lordship doesn't accept that as at face value.
There's no iota of evidence before you, my lord, of any prejudice caused by the first to fourth applicants, or any innuendo or suggestion that the first to fourth applicants have caused the Bank of Baroda any damage. So whatever they refer to in reports about what might transpire in the Oak Bay group or in the Sahara group does not assist your lordship in coming to a finding that the Bank of Baroda is suffering reputational damage. One would imagine then, if there was serious reputational risk, that the information exclusively within the knowledge of the bank that it has lost clients. There is no word of evidence that a single client has terminated its relationship with Bank of Baroda, that it has lost employees who are not prepared to work for it. There is no single allegation of that in the papers. There is not a suggestion of the turnover. In fact, they complain that the turnover has increased. The amount of work that they get from the applicants has become impossible for them to deal with.
And here are the arguments heard in court. The Bank of Baroda argued that it faces reputational damage if it continues association with Gupta-owned companies. Oak Bay Group counters that reputational damage, if any, is not related to the applicants. And the applicants say no proof has been provided to show any loss of clients, revenue or employees leaving the bank over the issue. The Bank of Baroda says they fear further fines by the South African Reserve Bank for failure to monitor suspicious transactions. Oak Bay says the bank was fined for issues not related to Oak Bay companies. It questions the bank that of the 72 reported suspicious transactions, only 5 were from 2017. And why didn't the Bank of Baroda sever ties in 2016? The Bank of Baroda says they want to close accounts due to adverse publicity around them. And Oak Bay says the bank is relying on invalid, irrational and unlawful grounds in its assessment. Further, several companies had no adverse publicity why close their accounts. And the Bank of Baroda says there is no constitutional right to a bank account, good faith or reasonableness, and this is to counter the applicant's argument that cutting ties are an infringement of their constitutional rights. The Bank of Baroda questions the argument of livelihoods at stake, saying that they do not pay salaries, they pay agents, and the Oak Bay Group clarified, saying the banks pay the pay agent who pays the employees.
And then in paragraph 93.5, the bank can disclose that in just a 10-month period, that is between September 2016 and July 2017, the applicants engaged in no less than 36 suspicious and unusual transactions with a combined value of over 4.25 billion, and the bank duly reported to the NIC. These transactions accounted for the overwhelming majority of suspicious and unusual transactions reported by the bank during this period. And you'll find Annexure 42 at 1043 to 1044. And then 73.1, in circumstances in which the applicant's banker-customer relationship with BRBs for an indefinite period, which is plainly the case, BRB is required to furnish the applicants with reasonable notice to terminate this relationship. Reasonable notice is determined with reference to all the facts and circumstances of the particular case. And in their recent heads, they now concede that reasonable notice is not only their subjective factors, but also the factors which are peculiar to the bank. I think that's at paragraph 67.5. My learned friend, Mr. Kukonicki, will find that.
But they fell foul of where the Reserve Bank had nothing to do with these applicants. They were taking cash deposits and not reporting them from other entities, and they had systems in place which the Reserve Bank found that were not sufficient. So their actual non-compliance is unrelated to the group accounts, and your Lordship will not have much regard or put much weight to this theoretical prejudice.
Joining us in studio is Tsepo Khadima, a political analyst, and Jackie Shandu is a political analyst. And the voice you heard in the background, there's Advocate Joseph Ngage. He's with Transform RSA as their advisor. And Mosiri Tsiane is with the South African Liberty Foundation, joining us on the phone. Good evening, gentlemen, and thank you so much for joining us. Let's just clarify on the rights as enshrined in the Constitution of whether you have the right to possess a bank account, as argued by Bank of Baroda. Advocate Ngage, we'll start with you.
I have a reason to believe that having an account is a right of every business or right of every individual. And as a result, the right to economic livelihood as it stands in the Constitution is very clear that if such a relationship has been established, then parties should be able to respect that relationship. And I've not able to hear whether in all papers before, Bank of Baroda is able to allude to the fact that there has been violation of contract between themselves and Oak Bay.
And I mean, just the rights of the customer as well. We're not necessarily discussing the merits or demerits of the case because it is sub judice.
Correct.
But it's in arguing that the perceived reputational damage, as we've seen, the other banks closing their accounts, and then this one almost being the lifeline, also now falling into that fray, using arguments of reputational damage without substantiating it. Tsepo, in your view, is that good corporate governance?
No, it's not only that, but it's also legally absurd that anybody could go and argue on the basis of, well, as we've seen with Bank of Baroda, and also what was alluded to by the other banks. But if I look at it, where are we now? First and foremost, I think I'd like to congratulate the Oak Bay directors for now finally having taken this thing that we have been urging them to do for the last 18 months. That is to approach the court on the basis that they have. And it is good that now the matter is there before court, and I think it is yet to be ventilated probably in the, well, case A, which will be in December 7 and 8. So that is that aside. But a banking account, it squarely falls within the constitutional rights, Chapter 2, which is the Bill of Rights, which are, you cannot do anything. They are cast in steel, the Chapter 2 rights in the Constitution, and having a bank account, and specifically a bank account, is nothing short of property, therefore protected under Section 25. What the bank merely is, the bank is merely a facility manager and not a property holder. Therefore, the person in this case who would have to have a bank account, that falls under property rights, and I think that has to be argued. But where do we go from here? From having listened to the arguments throughout the day before court by both counsels, I am more convinced now that the time has arrived in South Africa whereby some public interest body has to approach the Constitutional Court for a declaratory order that the banking institutions in South Africa be thenceforth declared quasi-organs of state. And I'm saying that for a specific reason, that you can only operate a banking business in South Africa under the Banks Act, which is specifically managed by the South African Reserve Bank, which is itself an organ of statute and an organ of state, as so specified in the Constitution of this republic. But also we know that the general public or businesses cannot directly deal with the South African Reserve Bank. The South African Reserve Bank has effectively de facto delegated its powers under the Banks Act, or the functions that ordinarily supposed to have of causing the creation of money and the banking to be able to happen, which is regulated. They have delegated that under the Act to the banking institutions, which are private sector organizations. Therefore, it is opportune now to have them declared as organs of quasi-organs of state for a very specific reason. As I've stated, in terms of that a bank account will certainly fall within the Constitution, and more so dignity. If you do not have a bank account in this country, your dignity is being impugned. And lastly, I want to say the following, and I back that up on the following point, Cindy. The city of Johannesburg, or Eskom, or Johannesburg Water, or Rand Water, cannot deny anyone to supply them water on the basis, or electricity on the basis of reputational damage, as so argued, and I must say, flimsily and weakly by Bank of Baroda et al., that we cannot give you because there's reputational damage, which they are not able to quantify. On the same basis, therefore, the banks have to be declared the quasi-organs of state, and an order right now is, I think, the best thing that should happen before the Constitutional Court, and the Constitutional Court justices will be compelled to have to grant it.
But I think there's some level of protection with the banks, within the Banking Act as well, that the bank can use its own discretion if you feel to be a persona non grata, and by association, and they do their risk assessment and what have you, other scientific methodologies, they can make that disclaimer and say, look, it's up to us, we've just fed up, we're not wanting to associate with you.
Lending is not transactional banking. We're talking about transactional banking. Lending will fall in a different sphere altogether. Here we're talking about transactional banking, your ability to hold money, which is property. Money is itself property in whatever form. Sure. Therefore, the property rights, and in this case of Oak Bay, have been violated. It cannot stand in this constitutional democracy that property rights of an entity are violated without recourse.
Yeah, your view, Jackie?
No, of course. I mean, I agree strongly, and I welcome the distinction between lending and transactional, because in this case before court, the only function of the bank is to facilitate transactions between Oak Bay and other companies who are part of this issue, between them and the people that they do business with. Nothing more. It's not a question of these companies wanting to get money from the banks. However, a wrong precedent was set when the big four South African banks closed account arbitrarily and they were not pursued. That set a very problematic precedent. We saw even prior to that, there was an issue, particularly with Fana Hlongwane, who was declared as a politically exposed person. What that tells you is that corporate South Africa, particularly the banks, have such amazing, enormous power that they do not account for that power to anyone. And this is very problematic in a democracy like South Africa, where, as Tsepo was saying, there's just no way to function without a bank account. And
But the court also can't overreach or, and encroach on the rights or the act in terms of how the banks operate. So if they're entitled to terminate an account without notice based on whatever observations that they've made, how is the court then going to navigate around that, Mr. Ngake or Advocate Ngake, in consideration that the rights of the customer here were violated?
Cindy, in order for the court to navigate, they should consider certain factors. Among the very interesting factor that should be considered is whether there is a breach of fiduciary duty. And whether there has been an unlawful interference with economic interest. Now, in these instances, probably that could be the argument that is now at play, whether reputational damages constitute economic interest. And that's a matter for court to determine. But then further, they have to make sure that at least they've given notice to the client. And in this case, even if they gave a notice to the client, it should show cause as to whether in their relationship of contract, is there a breach? And that is very critical for them to make that determination. But quite potently is the issue of social responsibility, social justice, Cindy. in all material fact, the vulnerable South Africans are entitled to be treated with due consideration of previously disadvantaged considerations. And in any determination, that is critical. Even if you make a decision as to whether it's justifiable for a person not to have an account, what will that account do if that person is not able to enter into economical livelihood? I think it's very critical to be mindful of that in that consideration.
Yeah. Is it the court's burden, though, to have to now prove the rationale around the perceived risk or association with the Oak Bay companies?
It's not possible for anybody to actually go there and say, this is the harm that I have suffered. We are therefore not surprised that today the counsel for Bank of Baroda could not in any shape or form or in affidavit have not been able to adduce the extent and quantify what reputational harm they have suffered. But it was in these very same studios after the unfortunate signing of the draconian and unconstitutional Financial Intelligence Center Amendment Act, that I made the assertion that we were then going to see that Bank of Baroda would come under unprecedented pressure from those that have been. Now here, I've stated it before, Nedbank is a subsidiary of Old Mutual. Old Mutual is chaired by none other than Trevor Manuel. And he is publicly on record in terms of his disdain for the Gupta family and in terms of the conduct that he himself has. So Trevor Manuel owes this nation, more specifically in terms of, since then, the signing of FICA Amendment Act into legislation, how many times he met with the Registrar of Banks, Kuben Naidu, and Kuben Naidu needs to explain to this nation in the number of times that he met with Trevor Manuel, what information he shared. And I challenge them this night that they must tell the South Africans what they did. Because the suspicion, unless contested with objective facts, will stay and stand that there has been unprecedented pressure, which is unlawful, which is completely abuse of power by these people. We must also be dismayed and appalled that the Registrar of Banks, as well as the Reserve Bank, have completely said nothing when they are the ones that license this, other than to have put this undue pressure, as it would appear, on Bank of Baroda to now take this unlawful step of even giving notice where they had not earned the right even to terminate, as today they could not show in court. So those are very pertinent issues that we must start demanding the answers from these public officials. And the banks, by the way, they are public entities under our constitution. I cannot see how they can be exempted and be still regarded as private sector entities that can willy-nilly privately, arbitrarily decide to take and violate constitutional rights of citizens.
We previously asked former Finance Minister Trevor Manuel on another matter to engage with us. So if he's watching, or we'll get our producers to send those questions to afford him the right of reply. But the issue about rights is that we tend to be selective in how it's applied in this country, depending on whether a person is appealing or somebody that you treat with disdain. And we've seen this happening with the Oak Bay group of companies. Even in court, the question was asked around how extensive has the reputational damage been? Have you lost revenue? Have your clients decided to distance themselves from you? Has your employees wanted to leave the organization because they feel that they're tarnished by association? That didn't come out, Jackie. So where are the rights of the customers?
Well, it also speaks to the problematic transition from apartheid to democracy, neoliberal democracy, which even in terms of the judiciary or when it comes to the sphere of rights and the law in this country, the criminal justice system to be precise, largely in favor of the white minority. You can see that these people were preparing for a justice system that would ensure that they are able, one, to retain everything that they had acquired unlawfully, morally, through violence and oppression. But number two, that the law would work in such a way that they would be able to defend themselves. And so there's a lot of things to be said about this. But what is also said, Cindy, is that for black people in this country, once you are shunned upon by white institutions, as we have seen with the banks, the lack of existence of black institutions, it then renders you in a very precarious position, because there's nothing you can do. Once that speaks to, again, the disproportionate power of white capital, of the white minority in this country, and that is why the fight against white monopoly capital is so difficult, because you are talking about people who are organized, you are talking about people who have institutions, you are talking about people who have money, and these public institutions, seemingly, also are influenced by this invisible hand of preserving white interest. There's no basis, none whatsoever. A business that employs over 7,000, largely black African people, its existence now becomes a matter that is of uncertainty, whether it's going to happen or not.
Yeah, but that's why it was so unprecedented. I mean, when the banks were closing in chorus, by the way, closing all the accounts, it was very peculiar in a sense that it's never been done before. And secondly, the fact that there hasn't been any proof. You know, so if there was evidence of any wrongdoing, I'm sure by now there would be convictions. And thirdly, the fact that the Oak Bay group of companies have been in existence almost from '93, you know, as long as our democracy. And things just started going awry most recently, about 3-4 years ago. So the thing about timing is also significant, because Bank of Baroda, for example, have been with the company for a year. So if there were problems about risk management or reputational risk, you would not even want to engage in a transactional relationship with the Oak Bay group of companies. Do you think that the court would want to pick that up as well?
I think it's very interesting to look to make that determination. We're looking forward for the court to make such a determination that will guide this country. I think we have been unable to have a situation where the 4 banks, when they closed the accounts, no legal process were followed. And I must appreciate the fact that this time the courts has been given an opportunity to apply their mind into this, and are very appreciative of the arguments raised. But surely I see this as nothing other than reaction to some agitations that are there within the public. And then those agitations, I think has got no much of a legal basis. There are just few of those irritations that you will always get when people have to apply their mind on matters of law, and I'm looking forward for that decision.
Okay, so the irritations in the public court of, or the court of public opinion, Khadima, would you say influence, or there's much more to it?
Well, I mean, what we are seeing is that we have an elite in this country that effectively abuses their power. We have, Nedbank, I think Mr. Brown is the CEO, is one of the 81 CEOs who have been political activists instead of being business leaders. And they've been left unchallenged. Whereas the memorandum of incorporation of their respective companies gives them no right whatsoever to actually use the companies that they lead into the political sphere. And their shareholders shamefully have said nothing. But we should not be surprised when we know that a subsidiary, Nedbank in this case, is of interest because it is an agent for Bank of Baroda. And that is in terms of our law, in terms of the Banks Act. So also this allegation that Nedbank has actually issued a notice now of termination of the agency agreement with Bank of Baroda. Again, that leads to nothing but abuse of power. So the question that must be asked is the following. Why is the Competition Commission so restrained from taking action? Why is the Registrar of Banks so constrained? If anything, what on earth is he doing having private meetings with the CEOs or some of the leaders of these various institutions that ordinarily is supposed to be supervising their actions and calling them into line where they err or where they effectively I would say, violate constitutional rights of citizens, which has happened in this case. And this is the abuse by the big moneyed corporations which must come to an end, because South Africans will not be pushed too far. The time is coming when nobody's going to be safe in this country if we have the moneyed corporations continuing in the vein that they are doing, as we have even in the woman who offered 2 billion rand for the president to step down without explaining what was the base of the 2 billion rand and where is she getting the money from?
Yeah, we're going to have to leave it there. Really appreciate it as always. That's Sepo Khadima and Jackie Shandu, political analyst, and we joined in studio by Advocate Joseph Ngake with the Transform. Maile Ngake, he even insists on his second name. Advocate Maile Ngake with Transform RSA. You at home, thanks indeed for staying with us. Do join us just after the short break.